The October 2022 meeting of the City of Fort Lauderdale Board of Adjustment. My name is Howard Nelson. I'm the chair of the board, or at least I will be for another hour or so. I'm going to ask you to please all put your cell phones or pagers or whatever other devices you have on vibrate or silent so you don't disrupt the meeting. And can we call the meeting to order? And Chadwick, your standard job.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Excellent as always. And my apologies in advance. I'm having some vision issues, so if you stand up and wave, you want to speak, and I don't recognize you, just wave louder, so to speak. All right. You should have in your packets the minutes from our September board meeting. Any proposed changes, comments, additions, deletions, corrections? Hearing none, I'll wait for a motion.
Motion to approve.
Second.
Approve the minutes, and a second by
Howard.
Howard Elfman. All in favor?
Aye.
Please show unanimous approval. All right. If everybody is signed in, can you please swear everybody in who will be speaking today?
Anyone who intends to speak, stand up, raise your right hand, please. Swear or affirm any testimony you give at this public hearing to be truthful and accurate? Thanks.
All right, thank you very much. And why don't we go right into the cases? Case number one is Lennar Homes. We are not going to be able to hear that case today because the chair needs to step down and recuse himself, and we don't have a quorum for that. So Dina, sorry you came all the way out, but that'll have to set to next month when we have more members. We got rid of that case quickly.
Sorry, yeah, that's quick enough.
When we move to case number two, Lakshmi Adapalli and Kranthi Alapati. And who's here representing that applicant? Very good. Why don't we go down the board for any disclosures? Chad?
No disclosures.
Which one are we on?
Number
Two.
two.
It was
Kate.
deferred from last meeting. It was the granny flat on the back corner up against the beach.
Right. So it's item number two in our agenda. It's Board of Adjustment item number 2208-0001, Adapalli. Any disclosures? All right, none for me.
Blaise McGinley, site visit.
Site visit and also read the letters.
Oh, okay, just, I drove by.
What?
I drove by.
Did a drive-by, okay. All right. Matthew, you want to introduce yourself for the record, name and address, and the floor is yours. I will have one question before you start, though, after you introduce yourself.
Okay. My name is Matt Rupasco. I'm the property manager for 3025 Center Avenue.
So we deferred this last month so that you'd have an opportunity to talk to the neighbors. Did you have an opportunity to do that?
Yes, we did. We
Okay.
did meet. I wanted call it a productive meeting. We had a belligerent neighbor come over and kind of disperse the meeting over some other nothing to do with my variance. It was over some other HOA policies or whatever they had going on. So I didn't get a chance to really speak to everyone. I individually spoke and dispersed after one of the neighbors was concerned for his safety and left.
Okay.
It was interesting.
The floor is yours.
Thank you. So the variance, what we're requesting is the granny flat to be put into, we want to legalize it. We're short on square footage and on the setbacks. So before, we'll talk about the hardship is that my client bought this property, which was listed on the MLS as a 4-bedroom, 4-bath, and also on Broward County Property Appraiser as a 4-bedroom, 4-bath with 2 units on the property. So for due diligence, that's sufficient in real estate. And then also property disclosure, seller's disclosure, didn't mention anything about, it did not have any violations prior to when we started our permitted work. So all we're trying to do is get it legalized the correct way. We were doing permitted work when the inspector came onto the property, and he just noticed it, asked what it was. We had no problem showing it to him, because in our mind, it was legal. And he let us know that it was not permitted. So we're applying for the variance just to go through and get it permitted, so it's legalized. It's been there for a long time, had no issues before. In fact, most people I spoke to, they have no issue with the variance. They keep referring to how we're going to use the house, when I've told them before, it's not registered one way or another. Our owner does use his properties, and it's not a coincidence that he bought a 4-bedroom house. His other home in Miami is also a 4-bedroom for him and his family to use. So while he's not a Florida resident, when I sent out the email, or the mail to each person in the tax map, I saw that it was actually 288 out of the 447 people mailing address was out of Florida. So 64% of the people weren't. So people talk about us not, or the owner not being a Florida resident, like it's going to impact their surroundings, but it has nothing to do with our
Okay.
variance request.
Matthew, I might want to suggest, just like I'm going to suggest to any members of the public, that you keep your presentation to the variance request.
Chair, if I may at this time, just to remind the board that this is a continuance of the prior hearing. So all the information and testimony that was received during the prior hearing
Has
can
been
be
moved
considered
forward. Right.
during this proceeding.
So yeah, I'll keep it towards the variance, which is just an invisible line that we need to be changed a setback to have a structure that's already built. There'll be less issues for our neighbors keeping the property as is and letting us get it legally permitted, rather than going the other way and having to change it back or turn it into a garage, which will cause construction and, loud noise during the day and night and whatever. So that was had nothing to do with us. We're just trying to do what the city wants.
Thank you.
Got it. I've got a couple of questions for staff, actually. If this was not a granny flat, but was just used as it was permitted for a garage, would they need the setback variance? Would they need the side yard
that-
setback variance?
That garage was built with a permit because we have found evidence that, in what was the year? I know, 1957, that garage was built with a permit. The city microfilm records have the records, and we found it, and the applicant has it, and I think he has produced it in the documents. So it can stay there as an existing non-conforming structure.
As long as it's still a garage, but the conversion would need a variance.
That's correct.
Okay. The original work on the property during which the inspector discovered the granny flat, was that work being done with a permit?
I was not there. And
Okay.
I think the owner's rep has told me, yes, they were actually doing in the main house.
Outside plumbing.
Go on the mic.
It was plumbing work on the outside with the permit, correct?
Okay, and it was being done with a permit?
With the permit, yes.
Okay. All right.
Yeah.
Any other questions from members of the board?
I have a question.
The house or plumbing the garage?
It was plumbing for the main house out to the street.
So the garage is still a garage, or the garage has been improved?
The garage was improved prior to us buying it, so we didn't do any work in.
Just weren't replumbing that. They were replumbing the main
But
house.
for the main house, the garage, we didn't do anything to it at all. We never touched it.
So let me start down at the end with Chad and we'll move forward. Chad, any questions for the applicant?
I have a question for staff. So I've got 6 letters of opposition. Is that the grand total? I just want to make sure I got them all, because there were some coming in later.
What, Shaquille? Yeah, whatever we have received, we have been sending you the emails every time, how many numbers we receive.
So I have 6.
collected, yeah.
I saw like 7 or 8, I think. Yeah.
Eh.
Mr. Elfman? All right, well, in that case, let me open up, if that was your presentation, let me open up for the public hearing. Yes, sir.
I was going to go, if I have the time, to go through some of the points made by the opposition on.
You
the-
want to reserve time for rebuttal?
Yes.
Okay. Any member of the public wishing to speak on this application? And your name and address for the record, sir.
Steve Gannon, President Lauderdale Beach Homeowners Association. I spoke here last month when we covered a lot of the details of the whole thing, and we left continuing it for the fact that, let me back up. I sent emails out to our membership, some of our membership that were more local, asking them to weigh in on this, which they sent, I believe, to the Board of Adjustment last month. What you asked us to do was, for the continuance, was to give Matt a chance to reach out more directly to the association. So we scheduled a meeting on site at his house. And I reached out to most of the local people, putting things in their mailboxes, very close, within 300 feet, a little further. I wanted to get people to come in there and listen to it and not just throw emails from afar. We ended up getting 3 proxy emails that said no. We got 10 households to attend the meeting, and we only allowed 1 vote per household, not, many people. Of the 10, all 10 did show up. They did, and 3 or 4 of them, they didn't get to hear the entire presentation because of a little disruption that was going on with someone else. More of them did. They all voted no. So out of 10, we have 10 no's. We have 3 proxy no's of the extras you asked us to do. I haven't submitted emails out to the entire membership, many of which live farther away yet. So I'm hoping the emails you received, they gauge the sentiment of the neighborhood. The sentiment is definitely, we don't grant variances on houses like that to add a bedroom or something similar, especially if it's encroaching. And that's what the board, and that's what everyone's doing. And this supports it, basically. I can go into more about other things here and there. I'll only say that I don't see much of a financial distress other than the fact that using the property at the best and highest use to get an extra bedroom that can rent out of it. The granny flat was not remodeled, so there's no extra money been put into the granny flat. It'll be just whatever cost is going to be to put it back to a garage. So it's not like it was a renovation like the house. The house definitely was renovated very nicely. There's no question about that. Did a nice job on it. It looks good.
And sir, I've got one question for you,
Yes.
because I noticed you said were not able to have a meeting of the entire membership, so I'm assuming you're speaking individually as a homeowner as opposed to as the president of the association?
I'm representing the membership has asked the board to always go against variances in the neighborhood that will add an extra bedroom. This is 8 years ago, when vacation rentals started happening. And they just said blanket, go against those. And that's what so I am representing the neighborhood. We got as many people to come to Matt's presentation. We only get 10, 15, maybe participate in a meeting, maybe 20 households in an annual meeting. That's the usual we get. It's just as
Sure.
much as we get.
Okay.
So we have reached out as best we could.
What?
I saw a lot of out-of-state.
There are a lot of folks in our neighborhood that are dual homes. They're snowbirds, basically. That's it, too. And they just can't attend these, especially at a time like this. They won't attend. So it doesn't mean that everyone's an LLC. We have probably 30% vacation rentals, 25% vacation rentals, which is a lot when you consider that they can affect 4 homes immediately next to them. And that's why we engage the sentiment where we try to keep the density down and people that are going to live there, or at least long-term rentals, but hopefully people that'll live there, even if it's part year.
Got it.
That's about it, all I have to
Okay.
say.
Thank you. Any other questions for the speaker? Okay. Any other member of the public wishing to speak on this matter? All right, even with my bad vision, I'm seeing none, so I'm going to close the public hearing. Matthew, if you want rebuttal?
Yes, thank you. So first, as we were legally renovating the home and we mentioned density, if we wanted to increase density, we would have just added an extra bedroom inside the house. The hardship was we bought a house, 4-bedroom, 4-bath, listed by the Broward County property appraiser as that. It has nothing to do with who's using it or when it's using it. And we talk about out-of-state people, and they want to have their homes. I have an out-of-state client. He wants to be able to use his home just like everyone else. He shouldn't be punished for the mistake or, I guess, misinformation on the Broward County Property Appraiser website. It was, this isn't self-inflicted damage to himself. And then I'll just go through some of the points which our neighbors have talked about. I've already touched on the fact that the majority of them don't live in the neighborhood. They talked about that we've created prior issues in the past. We don't have any evidence of that. Any issues that were done were just because it was permitted work that we were doing through the city. When we had to stop, we stopped. So the appearance of the house was just because we're following the rules. We're not going to talk about financial hardship because that's not something that we're here to talk about. I also should have the Broward County Property Appraiser printed out if you guys need to see the 4-bedroom, 2-unit. And then I guess one thing I want to leave you with is, like I said, he bought the house. He already has a 4-bedroom, 4-bath house in Miami. So this wasn't a coincidence that he bought this house. It isn't something that we're just magically trying to get this 4th bedroom out of. If we needed to, and we wanted to maximize the density, we could have just done that inside. And then last, the structure was already there. It's been there for a long time. The neighbors have not had a problem with it for the past however many years it was there. And I don't see a problem moving forward with it. The biggest problem would be my owner not being able to use his property that he bought that was listed as a 4-bedroom, 4-bath.
Got it. Any questions for the applicant before we close and have board discussion?
Chair, I just have one question. Does the owner have any intent to reserve the granny flat to rent out as affordable housing?
No. And if the house was rented while he was not using it, it wouldn't be rented separately either.
Thank you.
Okay. So, any discussion amongst the board? In that case, I'll await a motion.
Chair, I'd like to make a motion for case PLN BOA 22080001 to approve the variance for the reduction in the minimum lot size from 10,890 square feet to 9,003 square feet, as well as the variance for reduction in minimum 15 feet rear yard setback, as well as the reduction for minimum 5 feet north yard setback, and as well as a variance to allow the existing non-conforming structure.
I've got a motion. Is there a second?
Second.
Got a motion and a second. Any discussion before the vote? In that case, let's call roll.
Mr. Mead?
No.
Mr. Maxey?
No.
Mr. McGinley?
No.
Mr. Elfman?
No.
Chair Nelson?
No. Motion fails.
0 to 5.
We move on to the next case, which is case number Board of Adjustment 22080005. Paula Jean and Richard Emke. Ms. Toothaker, the floor is yours. But before you start with the floor you've just inherited, any disclosures, Chadwick?
Texted applicant's counsel.
What?
I text messaged applicant's counsel.
Okay. Doug?
Just trying to make sure I got the right case here.
We should put Doug at the other end.
The last undisclosure. You're lucky you moved, or you would have been the first one on this.
No, it's just the pictures don't make.
Any disclosures?
No, thank you, I got that. I just
Okay.
was talking about the right case.
Conversation with council and a drive-by.
Site visit, spoke with council, and spoke with some neighbors.
Site visit and spoke to council.
Got it. And I'm sorry, did you say spoke with the neighbor?
Yeah, I did.
You didn't wake him up in the morning
No.
or something? Get out here and talk to me? No, you didn't do that? Okay.
Door to door.
Ms. Toothaker, the floor is yours.
Thank you, Chair. Stephanie Toothaker on behalf of Rich and Paula Emke, who are here with me today, and Roy Edwards with my office. This is an application for a variance. It's got a couple of different variances that go with it, and I'm just going to walk through, if it's okay, I've got a PowerPoint presentation. The property is at 1400 Southwest 18th Court in Fort Lauderdale. and it is for an accessory structure with setback provisions. This is the subject property. As you can see from the aerial, this is very close to Lauderdale Marine Center, and it's outlined in red on the screen. The shade structure is a traditional cheeky hut that is next to the primary residence, which is a two-story residence, about 3,590 square feet. The property, the house was built in 2008, but the Emke's purchased the house in 2019. And it is a single-family residence in the River Oaks Association. So as I said, this is in a residential zoning district, but it is also adjacent to industrial, to the Boatyard Marina that's right there. So this is a really good vision of what a survey that shows you the outlay of the property. It's one of the things that I want to point out to you. So one of the variances that we are requesting is from a setback variance in the front yard. But in fact, if you look closely at the survey, you can see that the front of the house actually faces Southwest 14th Avenue. The entrance to the house is on Southwest 14th Avenue. I'm going to talk about that a little bit more. And you can see here outlined in red the location of the gazebo. So it is, as I said, it is a certified traditional cheeky hut constructed by the Seminole Tribe of Florida, and it is certified. And the builder does have the proper
Got the
licensing.
enrollment disc.
Yes, has the proper licensing to do that. So the variance requests are to request an existing freestanding shade structure with an outdoor kitchen to be located in the front yard. And as I showed you, it's a little awkward because it really looks more like the side yard, where the code allows the structure to be located in the rear yard. A variance to request a freestanding shade structure with outdoor kitchen to be 244 square feet. The code allows 200 square feet. It also is a request for a maximum height of 14.5 feet. So it's slightly higher than what the code permits, which I think was just a misunderstanding by the folks that built it. And also it has one wall that actually contains some structures in it. So I'm going to show you some images of that. And finally, the setback, as I discussed, we are requesting from the rear yard, which actually looks more like the side yard. So here's an image of the overall layout of the house, and you can see that the house actually faces the street that's on the right, but the city defines the front street to be the one that actually has the pool in it. So technically, pursuant to code, the pool sits in the front yard, and that's what's triggering the need for the variance for the location of the tiki hut, which is obviously immediately adjacent to the pool. So, as I said, the residence was built in 2008, and the residence was already, in its existing location on the site. When the Emke's bought the house, they added the pool and the tiki hut. So the building, obviously, the house has, a large footprint, as most of the homes that are built today, and the house is completely compliant with the setback requirements. So here's just a view inside the shade structure. It's not, as I said, one of the variance requests is for a little bit more square footage. I don't think it looks excessively large. In fact, if you look at it carefully, you basically have anything that you build a modern outdoor kitchen in. You've got your refrigerator, your stove top, all the things that you would expect to see, probably an ice maker, and then just barely enough room for a small table inside, so that you can actually be out of the elements when you sit down to eat, after grilling your food, hopefully. The next variance is a variance to request a freestanding shade structure that has a height of 2.5 feet higher than what the code permits. I would say to you that if you drop that tiki hut a little bit lower, you're actually getting a little close to the grill with the palm fronds that come down. And so I would say that, and I think it's important as well that the height doesn't conflict with it doesn't conflict with the trees on the site, and it doesn't conflict with the height of the overhang of the first story of the home itself.
Is the height being measured from the top of the ridge line of the chickie, or midway
Yes.
down the roof line?
I'm getting yes from the audience that it's from the very top of the height of the cheeky, the point at the top.
And I'm going to stop you for 1 second to ask staff a question. When we measure roof height on pitched roofs, do we measure from the peak, or do we measure from the midline between the peak and the wall line?
Peak to the peak.
Peak,
Yes, to the ridge, to the top of the ridge.
got it. Okay.
So that's obviously triggering one of the variance requests. The next one is for the existing freestanding shade structure with outdoor kitchen to have a full white wall. You may remember that I was before this board not that long ago with another freestanding shade structure that was exterior to a new home that had been built, and the contractor had included outdoor kitchen equipment through it, and the code at that time did actually not permit that. It had to be free and open on all sides. We were successful in that variance for that homeowner, and actually the staff, thank you, Mom and Bert, came behind us and actually amended the code because they said, that doesn't make a lot of sense. I would venture to say this is a similar scenario. You see a lot of these. I actually have something similar in my own home where if you're gonna have, some entertainment uses outdoor, it's very hard to do that unless you want to just put your TV on top of your 42-inch height. So that's the purpose of that. And I also think it creates a bit of a sound buffer to what the city is defining as the front of the house. So the last variance request is for a variance for the 25-foot minimum front yard requirement. And as I showed you in the earlier slide, it's actually quite awkward because the front of the property actually faces 14th Avenue. That's the primary front door of the home. And the home, was built, as I said, the Emke's purchased it after it had been built, many years after it had been built. They added the pool and the shade structure. And as I said, the contractor that built the shade structure, I don't think it was a total disregard of the ordinance. I think it was probably a bit of a misunderstanding about what the ordinance permitted. I'm actually working on another tiki hut right now. Again, the company that was certified to be able to build it for the Miccosukee tribe, in that case, just wasn't aware that they needed the zoning permits. You're allowed to build it, but you still have to comply with certain things. And I do believe there's a bit of a misunderstanding about the law that you still have to go through the city. And so I believe in large part that's what happened here. So one thing that I want to point out that's also very important is that the tiki hut does comply with the setback that is adjacent to the property that you're looking at on the left here. So that is not one of we don't need a variance because it's in the proper location as it relates to the neighbor that is directly adjacent to us. It's actually a variance from the road, and that we show you that measurement there. So it's actually 39 feet from the property owner that is across the street, and that's where the variance request is being requested. And I wanted to point out again, so pursuant to 4719-2, freestanding shade structures such as a gazebo, tiki hut, which we have here, obviously may be permitted when accessory to residential uses. So these are permitted structures. You see them all over Fort Lauderdale. In the required rear yard, no closer than 5 feet. If this was the rear yard, we would not need to ask for such a large variance. And obviously this is, as you looked at the home from an aerial perspective, it's the only place you could put a pool. There is nowhere else on the property where you could put a pool and enjoy your outdoor spaces, as we all did, particularly in a post-COVID world. So the variance request looks a little bigger, I think, than on paper than it actually is in reality. If you look at it like that's, that's your if that were technically your rear yard, you'd only be, 2.5 feet off from what's actually required. But because we're being, forced to define it as our front yard, even though it's not used as a front yard, that's what triggers the need for the 25-foot variance. I think that's a really significant point. We do believe that special conditions and circumstances are in place here. For one, the Emke's bought this property. It's a beautiful home in the beautiful neighborhood, but they bought it, obviously thinking that they could add a pool. And, most people, I will tell you, most homes that you go to today and you want to enjoy the outside, but you've got to have some shade. You can't just sit and bake in the sun. So adding a freestanding shade structure, I think, is appropriate, and it's quite common. In fact, every modern home that's built always contains one of these. So I think, I believe that it meets this criteria. That the circumstances which cause the conditions are peculiar to the property at issue. I think just by virtue of what I showed you, how the house is oriented on the street, I think the mic just went out. How the house is oriented on the street and how the house is oriented on the property, you kind of have to question which side is really the front and which side is the side and which side is the rear. The literal application of the provisions of the ULDR, I do believe, would deprive them of the ability to use the outside. It is, as I said, it is a shade structure. It is certainly compatible with what they have, and it's compatible with generally what's happening in the area. It was not self-created. The shade structure, as I said, was added by the MKs, but it was also done by a contractor, that is certified to build the cheeky huts. And I do believe it was just a bit of a misunderstanding about the fact that you still have to comply with the zoning criteria. So obviously that's why we're here, and we hope that you'll support the variance. And I do believe it's the minimum variance. If you look at the images, and I wanted to just add a few more, you really can't even see it from, it's significantly shorter than the home. They've got dense, lush landscaping all around the property. And from most instances, you really can't even see it. And here you're looking straight on the image that's on the left. You're looking straight on, and with all the trees and landscaping that they have, it's barely visible. And as I said, I think this is also an important image because the property that you can see, that small house that's immediately adjacent with the black windows, that the tiki hut complies with the setback on that side. We are not asking for a variance from that side of the tiki hut. And just some more images, you can see it's got a very wide, setback from the tiki hut to that wall. There's a wall, then there's landscaping. You can see this is the side of their home where the tiki hut sits, and it's right in line with where the location of the pool is, and it's not, as I shown you before, with the table, the small round table and chairs on the inside. It's not overly large. We do have letters of support from neighbors on 3 sides. So we have a letter of support, highlight the subject property is highlighted in red. The letter highlighted in green is our neighbor, the Heberts. They were very pleased to write a letter of support. The neighbor outlined in blue is Whitney Dutton, and Whitney was very pleased to write a letter of support. Immediately depending on how you want to define it, but the property in purple that's on the side or rear or whatever, however you want to describe it, also wrote a nice letter of support, Bill Waite. And finally, Governor Stamper down at the end is also a friend that wrote a letter of support. Before I close, I would just like to have Paula come up and just say a few words about their family and how they use the property. And one thing that came up, and I brought this to the MKs to their attention. They have a very large family. They have 7 children. The children love the property. They use it quite frequently. They come, I think Paula will share some things with you, but I think they were not aware. There was a feedback from one of the neighbors that maybe when the 7 kids are over, that might be a little loud outside. So I brought that to their attention. I think they are very, sensitive to that fact and are very, really, really listening to that and would like to have the opportunity to address that issue and maybe keep the noise down a little bit. I don't think that's something that they were really quite aware of. Particularly, I think if you have 7 kids, I think you can appreciate, and especially a lot of them are high school age and older, maybe they're not so quiet all the time. But Paula, why don't you come up and say a few words?
Got it. And we'll note for the record, I think 1 letter of objection, 4 letters of support and 1 letter of objection.
That's my understanding. Yes, thank you.
The letter, the house to the west? Which was it?
Mike. Microphone.
Oh, was the letter of objection the house to the west?
Stephanie. The letter of objection.
I believe
where
it was the little house next door with the black windows. I believe that was the letter of objection. But whether that's the rear or side or it's hard to, but I believe that's where the letter came from.
Hello, my name is Paula Emke. Actually, I became a Florida resident back in 1993. I bought my first home in 1997. I moved away in 2008, got remarried, and I told my husband I missed South Florida and I wanted to come back. We really were the American dream. We came here, we rented a home, we started a business. 3 years later, we bought this home December 2019. What happened in January 2020? The pandemic. We had kids that needed to move home from college. We had adult kids who couldn't make their rent. We have a special needs kid who's autistic. and a teenager. We had a lot going on. And on top of it, my husband was trying to build me my dream home, give me my forever home, and blend a family of 7 kids. That's all we wanted to do, is to beautify the neighborhood. I love South Florida. I'm actually a Floridian and a Californian, but I love it here. And I never wanted to upset anyone. We just wanted to make it look beautiful. And I'm just so blessed that my daughter, she's her junior year at St. Thomas. All her friends come over after Friday night lights and swim in the pool and play basketball and listen to music. And we're home, and it's wonderful. And our other kids that are in California, they come here in the winter. They're adult, kids, 25, 28, 29. They get a little loud. I always tell them after 10, we got to bring it down. So please, just going forward, I believe in the love thy neighbor. If you have an issue, let us know. I've given my neighbor who's been objective my number when he first moved in. I even gave him a tour of my home, told him a little background about our family. I mean, we're a great family, and I just wanted to also tell my husband thank you. And thank you for the beautiful home that you provided for us and created for us. Our kids and our family, we love it. So please, that's all I wanted to say. Thank you.
Thank you. Before we
Thank
open
you
for
very much.
public hearing, any questions for Ms. Toothaker?
I have a question. Stephanie, and I couldn't make it out from the slides, but was the full height wall, is that already there?
The wall is already there. Yes. The wall and the landscaping are all there in place. Yes.
I know the landscaping, that's why I couldn't see if the wall was actually there. Thank you.
I had a couple questions.
Yes.
What's the distance from the hut to the asphalt of the street?
The distance from the hut to the asphalt. Let me go back to the survey. I'm going to go back to the beginning where
Good
it's
question,
easier to see.
29, by the way.
It's
Did I look?
19 feet. 19 feet.
To the asphalt?
Because the grass is actually outside the property line. So obviously, when you measure setback, you have to measure to the property line, even though the aerial, if you look at the aerial perspective, it doesn't, you can see that it's all grass and landscaping, but it's technically outside their property line. So it's 19 feet to the pavement.
Okay, and how high is the top of the gazebo from the ground? I mean,
How
I'm
it's
assuming it's a platform or a deck, so it's higher than.
It's on the deck, right? Yes, it's on the deck.
So what's the height?
So the height of, that's one of the variances that we're asking for. It is 14.5 feet from the deck.
From the deck, right?
But
What's
it's,
the
but,
height from the top of the 14.5 to the actual street or ground?
oh, I don't know that, we didn't have to measure that for the variance. I'm sorry, I don't have the answer to that. But again, if you look at the picture of the tiki hut on the left, you're really, that 2.5 feet is actually just the pitch that's right at the top. I'm sorry?
Still a height.
Yes, it depends. I mean, it depends. If this was a residential, like multifamily building, you wouldn't measure that. You measure to your interior space, or if it was flat roofed. If it was flat roofed, you wouldn't measure that either. It's the way that it's being measured. Yeah, it's true.
Ms.
Yes.
Toothaker, can you go back to your survey? Because I looked at the survey before. No, 19 feet, you're right, never mind. Where 25 is required.
If this
If
were
indeed
the
that was part of your property.
if it were the rear yard, if it were the front yard, 25 feet would be required. Yes, and that's how the city asked us to measure it.
Okay.
Even though the front of the house actually faces 14th Avenue.
Well, do you want to reserve some time for
I
rebuttal?
would. Thank you.
Okay, so let me open up the public hearing. Any member of the public who would wish to speak on this? Your name and address for the record.
Yes, hello, my name is Derek, and my address is 1404 Southwest 18 Court. I'm actually the next lot neighbor, just on the west of the property, the small house that they mentioned. And just to punctualize, I think you mentioned a letter of objection from a house with black frames. I do have in dark blue, but I'm not the one who brought any letter of objection to you by email.
I want you to back up because I'm not sure I heard that
No,
last
I'm
sentence.
sorry, no. They mentioned that there wasn't a letter of objection that you mentioned, but from the description that they see from the house, it gave the idea that it was my house, but it wasn't my house.
So you're the adjoining western neighbor and you're not objecting?
No, and I'm objecting to this.
Okay, got it.
I'm sorry. Sorry for the misunderstanding.
Okay, I'm easily confused.
Okay, and before starting, I also have one thing. We received on our email the notification from this variant. for September 14, and then it was postponed. But this time, the neighbors did not receive a mail. So that's why some of the neighbors who last September attended, they didn't attend it this month. And they oppose actually the request for this variance. And some of them are old people, so I don't think they have access to the same technology information that we do. But anyway, just to start it, to be honest, for me it's difficult to understand why we are here meeting for a request of variance, because what we are talking about here is a code violation. This code violation was brought to light by the Inspector Alexander Boris on 18th June 2021. It's been almost 1 year and a half, and since then there hasn't been any resolution. When the inspector went to the property, according to the Lauderdale bill record, so everything is online, they issue one stop work order. A few days later, he came and he had to issue a second work order for doing work without permit. And apparently, according to the records, the owner, textually, the owner agreed to stop work until permit is issued. But still, we see that this sticky hat has been going on since then. Then the inspectors postpone, they give extensions days to legalize the sticky hat, and then they send it to the board, to the Code Enforcement Board. And the Code Enforcement Board every month has been meeting, and apparently they did nothing from what I see on the records until this last July or August, there was the application for this variance. So what we are here, honestly, I don't think here it's a question of, besides that it doesn't comply, first of all, it's a code violation. So I would like to say here that in some of the texts and the documents that were submitted for that, they specify an existing building. I don't think we can define an illegal structure as an existing building because it was built 2 years ago, not with an old Florida building code. So that's one thing. So, I totally oppose this project for three main reasons that I'm going to try to summarize as quick as possible. First of all, for a safety issue, I'm very afraid of having this type of sticky hat with gas, with sabal palms, with a kitchen next to my house. And in the case that there is a hurricane like we had with Ian, what's going to happen to the adjoining properties? I mean, for me, and my understanding is that we have to hope for the best, but prepare for the worst. And one of the ways to do that is to prevent weird things, exceptional things to the Florida Building Code as much as possible for the safety of everybody, and also as a homeowner, to avoid having homeowners insurance policy increase every year, having to face with so many issues that can happen. And I think that the Hurricane Ian has been a total proof that things have to be done the right way and that we don't have to take exceptions lightly. So an exception that has some fundamentals, they can be approved. But this kind of things that doesn't really bring anything essential to a house, they shouldn't be allowed from my point of view. So for a safety issue, I totally oppose that. Secondly, what they say dream home, when they refer to dream home or dream structure or whatever, it's my nightmare. Because even if they say on the submittal papers that they didn't, that no neighbor complained, I actually complained many times, and I had to call the inspectors or the Fort Lauderdale Police Department because they were playing the music very loud, and every week the neighborhood, my street, transforms into a sports bar, having to hear the match parties, the sports events, or having to listen to music that, of course, I don't deserve to listen in because I bought a house to enjoy my property in quietness without disturbances from anybody. Otherwise, I would go to, I don't know, maybe to the entertainment district. When you go to entertainment district, of course, there's a zoning law that applies there, and it doesn't apply to the residential because residential is for sleeping, for working, for living. And I think that we can all live together and we can all have our own way of living our life. But I don't think that it has to put any interference to other people. So what people can say that this is the right for some activities, for me, it's not a right. It's actually, they are running out, they are running my rights as a homeowner to live quietly, peacefully in my neighborhood. So this is also one of the reasons that has become a source of conflict. And what really unnerves me, because even if I have hurricane impact doors and windows, I still hear the music many times. I have thousands and thousands of records from all my cameras that I have around, that even the farthest camera on the other side of my house at 2 a.m. could record sometimes the music. It didn't happen so often, fortunately, at 2 a.m., but it does happen from time to time. So I would even like to spend more time outside, but you know, when you want to relax, do some gardening, whatever, there's no way I can do it, because you have the neighbor playing the music. Why? Why do I have to listen to that? I mean, I just want to enjoy them. If they want to play the music, that's fine, but play inside the home or to such a level that nobody can hear it. I mean, and I don't think this is difficult to understand. I think that this is something reasonable for everybody. So that's one thing. And finally, another final thing, to summarize, I'm also deeply concerned about my property value. Because even if they say that the entrance is on the avenue, if you check the records, the map records that it's on the Fort Lauderdale building department, on the archives, you can see that the main entrance is actually in the 18th court. And it's very easy also to detect that, because the mailbox is located there. They didn't move the mailbox to that avenue or request any change there. So actually, that's the front yard, no matter what. So I'm very concerned that if I have to put my property for sale or for rent eventually, that people would be deterred of renting or buying my house because a neighbor doesn't want to legalize a tiki hut, and I have to pay the price for their own decisions, which I think it doesn't concern me. And then, so those are my three things. Basically, safety issues, all this noise that comes from there, and finally, for my property value. As I mentioned, for me also one of the aspects is the security, and I don't think we can spend time or we can take those things lightly when we know how devastating hurricanes can be right now. And final point, two things. I'm sorry, there's more technical things, more aspects, more from that. So on the hearing package that we receive and that we have here, the plans are actually signed and sealed. However, the plans that were uploaded on the Lauderdale Bill website, what I see from the records, they were not signed and sealed, but they were still reviewed. I'm not sure if this is something consistent with the city guidelines, but as far as I understand, and I did all the permitting for my house, they always requested to have all the permits signed and sealed to make sure that the architect, the engineer, or whoever has to sign this is aware of what he is doing on paper, not for any liability or civil responsibility. So that's one of the things that I see on the package, that there wasn't the signature. And finally, when you see the property records on Lauderdale Bill, you see that they actually pull out, or they try to pull out a permit for a tiki hut structure, but it was void. My point of view is that if they requested that permit and it was then void, I understand that they knew what they were doing and they knew that that wasn't allowed, but they even proceed to do that. So that's one of my understandings, especially since we had 2 stop work orders. And just another thing to finalize, I don't want to extend anymore, I'm so sorry, but I really need to give you all my explanation.
I didn't mention at the beginning that generally public comment is 5 minutes, but we're not going to enforce it.
Okay, thank you. And then the criteria for the variance request here, there are some aspects that I don't think they are accurate, and they don't give any criteria that can apply a variance for this case. We shouldn't forget that this is a code violation first, so this is not any special request, and it wasn't a structure that was built. So as you know, here on criteria of approval variance request, I'm not going to read everything. I'm just going to say to which a statement it belongs. So on point number A, the orientation of the primary residence on the property is not a special condition in this case. It's just a standard corner lot, like many other multiple houses, and there are many other houses with that size and who doesn't have those type of problems. So I don't think this is a special criteria to follow. And it's very clear, the Unified Line Development Review, that those type of kitchens, tiki, they cannot be located at any moment in the front yard, as this is the case. And even if they submit an appendix with an exhibit with an reinterpretation of this reinterpretation from an inspector or from the city, they always state that they can allow it on rear or backyard, but never in the front yard. And this is the case. This is in the front yard no matter what. So there is no way, I believe, that the law can say that. So
Thank you,
that's one
sir.
thing.
Thank you. Before,
I'm sorry, just a sentence, I'm sorry, and that's it. And then I check all the special requirements for that. I check property by property in River Oaks Neighborhood Association. I see 780 lots. Out from that, this lot is on the 20% of the largest lots. That means that 80% of the lots in our neighborhood are smaller. And I don't think they are dealing with this matter. So, and just to finalize, I also brought here my architect, who is registered and licensed in the state of Florida and Georgia, who can also recommend or give some statements on more related to the development laws.
so 2 things before you leave the podium. I'm not sure we got your last name onto the record. I think we just got your first name. So
Yes.
if you could just repeat your first and last name.
Derek Fernandez.
Perfect. Any questions from the board for Mr. Fernandez?
Very impressive presentation. That was very detailed, very well thought out.
Very good. Any other members
Mr.
of
Chair,
the
I
public?
would just
Yes.
like to say, understanding there's a noise issue, that is a separate code department, and that should be addressed with the code enforcement for noise. This is a board
Well,
hearing
there's not a
for
noise variance
variance,
going
so
on,
just-
but we
just-
understand
just
the sentiment.
Recommending he go
Right.
to that part of the.
Yes,
the
I'm
city.
already in
Thank
charge
you.
and also seeking legal advice, so.
Any other member of the public wishing to speak? And sir, I'm just going to ask you, because we really do keep these to 5 minutes, to keep your comments
He
directed.
used up 3 of your minutes.
Your name and address for the record.
Hello, my name is Joaquin Fernandez. Also, I have the same surname. I'm a friend of Derek. Also, I'm the architect that he hired me to do the interior work and remodeling and all the interior works he did. I'm aware of the situation because as a closer friend, I don't want to explain the same that he did it, so he explained great. I come in here as an architect. So as an architect, having the commitment with the society that any client can ask me, can I do in my home? And I say, look, this is the front yard. This is the front yard, has a requirements. You have to do and follow the rules because I cannot sign and seal any plan that cannot be approved in the city. I don't know why we stay here today to see, look, you can do whatever you want because you can go to a hearing to get approved. So this is something as an architect, commitment with the society because my profession, close to the city department, we are working together to get a better the city. And we are working for the society at the end. I'm not working for my client. We're working for everyone. And this is an architect commitment. And this is, I come here to say something like, because everything is explained. It's the front yard, no auxiliary building allowed in the front, has a violation, is aware everything was done without permit. I don't have anything to say, that my opinion is no.
Thank you.
Thank you.
Sir, I have a question for the
Yes.
architect. So in your professional opinion, based on the way the house is oriented with the front door facing the side street, you do not believe that where the pool is located would be a rear yard in any other type of structure?
Or a side yard.
Legally, the front yard is in the 18 is.
I'm asking you as an architect,
As an
not with regards to
Right.
our city code. I'm asking you as an architect, in this house, is that location of where the pool is, do you technically consider that the front yard as an architect? Not legally, as an architect, when you're designing it.
As an architect, we don't know any, so we don't see any code. I will say side yard, no back yard.
I agree. So I'm asking you as an architect.
Correct,
not
but your
code.
composition of the street and the urban design is considered front yard.
That's
so
the law. Are you saying, as an architect, you agree with that assessment?
What, repeat? Yeah, I don't hear you.
I'm just asking you, if as an architect, as you see the house is oriented, do you agree with the assessment that the pool area is in the front yard of the house as an architectural design of the house?
Well, to make a clarification of that, actually, the house is the front yard, is in the street that it was located, the entry, you can see in Zillow, the main entry was in 18 Court. They
Right.
changed the site they changed the entry, but the house is the same before that. it's a corner lot. This is a special thing.
So you're saying there was a remodel that changed the
They
entryway
changed the original entry.
to a different side of the house? Okay.
Originally, it was in the front.
Okay, thank you.
Thank you.
Ms. Toothaker, any rebuttal?
Thank you.
Well, I'm sorry. Any other members of the public that wish to speak on this? In which case, let me close the public hearing. Ms. Toothaker, do you have any rebuttal?
Thank you, Chair. Mr. Emke would also like to say a few words, but I do want to point out that the neighbors' objections that we're aware of relate to noise, not to the structure itself. The pool is proper. It's in the proper location. The 7 children using the pool, that's not going to go away. You could take the top of the structure away, which creates the need for the variance, but the pool and the use of the pool is likely not going to change. The neighbor has called the police on a large number of occasions, and the Emkes have never been cited. The police have never cited them for noise. They've said, we don't think you're in violation, we don't think there's an issue, but it is true that the neighbor has called the police on a large number of occasions, but they've never been cited for noise. The code matter that he's referring to relates to the structure. So that's on hold. It is in permitting. It has passed some of the requirements. It's all, from what we can see, it's all properly done, but it's on hold subject to this variance. We've actually been working on this variance request for quite some time, and I think you are aware I deferred it last month because
Right.
I had a conflict.
Which leads me to a question for staff, actually. And you guys can correct me if my historical understanding has always been wrong. A tribally built chickie, one which has a certification, requires a zoning confirmation to determine if it is in the proper setbacks and location, but does not require a City of Fort Lauderdale building permit. Is that correct?
That's correct.
Okay.
Subjected to, all Florida building code requirement. The
Right.
Board of Rules and Appeals have made that, if it's.
Okay.
If the chair will allow, Mr. Emke would just like to say a few closing words.
Before we do, I have some questions. Howard. The other Howard.
I'm also happy to answer other
I feel like
questions.
I'm talking to myself when it's Howard. I just have a couple questions for staff, and Stephanie, you as well, so I'll get them in there. As far as it was alluded to the permit, and I know you said the permit's for the Cheeky Hut.
Sorry, I didn't hear you. I'm sorry.
Okay, so the permit's for the Cheeky Hut, but also the kitchen that's there and the wall that's there. Has that been permitted already?
It's all on hold at the city pending this. But if I would rather not offer this. If we had to take the Cheeky Hut off, which is the part that's causing the need for the variance, the other we could take through permitting. The rest of everything would be exposed to the elements. But it's proper, it's permitted.
Thank you. And just one question for staff real quick. If we do have hurricanes down here and Cheeky Huts are pretty good, but for some reason if it blew away and we were to grant this variance and they were going to replace it, do they automatically get to replace it with the height that it's at, or would it have to be compliant with what it's supposed to be?
We could stipulate that it would comply with code from a height perspective,
Once
if that happened.
a variance is granted, it could be built. Am I correct?
The board can accept the applicant's stipulation or stipulate itself in the order that if it were to be.
Rebuild would have to comply
rebuilt.
with the height requirements.
Okay, thank you.
But without such stipulation, yes, they would be able to rebuild.
We're happy to stipulate that.
I have a board question.
Yes.
If the height of this is too high, is this legal in any part of the city or just not in this neighborhood? They want a variance for the height because it's 14 and a half feet high. Is that 14 and a half feet legal anywhere in the city?
The code is throughout the city. The code is throughout the city. This is the same code. That's the question you're asking.
For freestanding shade
For
structure.
freestanding structures, right. Except for county annexed areas, it's a different code, but for the rest of the city, it's the same code.
So this is legal nowhere in the city of Fort Lauderdale? Okay.
Mr. Chair, I have a question for staff as well. I know we've done this in a board hearing before with regards to the changing of the orientation of the house. We've reviewed that before. Can you just remind me, if something like this happens, clearly the front of the house was the front yard where the pool structure is currently sitting, but there was a remodel done that now puts the front yard onto the side structure.
The
What does
front-
this?
The front of the lot is
Right.
what's determined, not necessarily the orientation of the house,
Okay.
but the narrow side of the lot is the
The
front.
front yard, right.
Right.
Okay. And like I said, I know we've looked at other variances in the past where
And granted.
it makes, yeah, it does not make sense for the front yard because that's not where the entryway and that's not where the garage is. But there's nothing that happens within the city during an architectural remodel in which they would adjust that.
Because it doesn't deal with the house, it deals with
deals
the
with the lot.
shape of the lot.
Got it. Thank you.
What?
Relationship to the street.
So is that a question for staff?
Sorry, I jumped in and answered the staff question, but
Okay.
did I
So-
answer it correctly, by the way?
I didn't hear what you said.
Okay.
So we often get asked this from applicants, is there a code section that states that the front door has to be at the front, in the front yard? And the answer is no. It often goes that way. What determines the front yard is the setback. Front yard is a 25-foot setback. And then just for clarity, there are no side yards in a front yard setback. The front yard setback is from side property line to side property line.
So, Bert, in determining what is the front yard versus the side yard versus the rear yard, does the house and the orientation of the house on that lot have anything to do with that determination?
No, it doesn't.
Okay. That was basically the question. If they reoriented the house, would it shift what is the front yard? And the answer was it's the shape of the lot and how it faces the street or streets that determines what's a front yard,
And they
a
more
side
than
yard,
they
and a
more
rear
than
yard.
likely requested it to be set up that way with the entrance on the corner yard. That was probably the way they designed it.
So this property has a front yard and a corner yard. The other street, whichever you want to say, it's a corner yard.
All
Thank you.
right, any other questions from the board?
And then just
I'm
for
sorry?
another clarification, there's also a corner yard setback that's more than the side yard.
Ms. Toothaker, are you
Mr. Emke would just
finished?
like to say a few closing words. Thank you.
Okay.
Thank you, Board. My name is Richard Emke. I'm the resident at 1400 Southwest 18th Court. One thing I wanted to address quickly was, it's come up on multiple occasions about the height of the tiki hut. When the company put the tiki hut in, he, in fact, spoke with, and I don't know who, he spoke with somebody at the city because the actual ground level for our house is 26 inches above where the floor starts for the actual tiki hut, because the pad, there's a pad that was up on the house. In fact, you can see it in the photographs that Ms. Toothaker had presented, as far as it wraps all the way around the house to both doors, as far as that was considered zero in the communication that he had before he had put it in. So I wanted to address that as far as the height situation. In closing, it's unfortunate that we have the situation next door with Mr. Fernandez. We dealt with him during the construction. We tried to offer the olive branch many, many times, if you will, to other neighbors as well. In fact, every year we have a Super Bowl party. Unfortunately, this past year, the police were called by Mr. Fernandez concerning this. We've always told all of our neighbors, anything that you need, we want to make sure that we're good neighbors at the end of the day. And I know we're not here, quote unquote, for a noise variance. I know that was a significant point of contention, but we're here to do anything we can to try to make this as peaceful as possible. We appreciate your time.
Thank you. And just so it's very
Actually, I
clear,
have a question.
there are no noise variances in the city.
I
That's not a thing,
actually
so-
have a question.
Andrew, don't think about asking for one.
I have a
Okay.
quick question.
Yes, sir.
Had you applied for a permit for this building?
No, initially, we did not apply for the Tiki Hut because, again, we were communicated, and I am a new Floridian, so I had no idea. So I took the advice of the company and said no, that there was not a permit that was required for the Tiki Hut.
That's not my question, though.
Oh, I'm sorry, my apologies.
Were you made aware of the setback requirements associated with this Tiki Hut before?
Not prior to the installation.
So in none of your discussions with the city You were under oath.
Correct.
So in any of the discussions you had with the city or staff, but prior to the building of this tiki hut, you were never informed that this could potentially be,
No, there was no, I didn't have any discussions personally.
because I could have sworn I heard that other guy say that there was an application made and it was denied. So do you don't have any denied applications?
No, we didn't have, at the time that the tiki hut was installed, there was no application that was submitted.
I'm talking about before that, like when
Well,
you.
so let's put, are there any, excuse me, any denied applications on this property?
There is a prior voided permit application. The description calls it a patio.
Can you state the date for the record, please?
Wait, I'm sorry, the last two words.
The job description says it's for a patio, but it was voided.
Got it. Okay.
So technically, we are not sure because we are looking at the screen here. Was it for that? We are not sure. It just says on the screen, they have applied for a permit for a patio.
I understand.
And it was voided. So we are not sure, was it for this or anything else? We are not.
Okay. All right.
Chair, before your deliberation, just a reminder of the voting requirements in the code that a majority plus one of the membership of the board present and voting would be necessary to validate any orders.
4 out of
Therefore, a
the 5
unanimous vote of the board tonight would be required for an approval of any variance.
1, 2, 3, 4, 5. A majority is 3 plus 1.
I stand corrected on the math. That's why I'm an attorney, not a mathematician.
I stayed up.
4.
This is why I got an LLM, because we did math in that.
Was there a final?
Mr. Emke said that they had submitted a permit for a patio extension that had nothing to do with a tiki hut.
Exactly.
It was voided because they decided to go in a
Got
different
it.
direction. They were advised by the company that did the tiki hut that these could be
Right.
done without permits, which is
No, so that we're clear, while the tiki hut does not require a permit, all the build-out inside the tiki hut, the kitchen, the electricity,
Yes.
all of that stuff, does require a permit.
yes.
Board, just to clarify,
Sir, I'm sorry, the public hearing is closed.
a chicky hut is built by either a Seminole tribesman or a Mississauga tribesman.
Right.
There can be nothing but the chicky hut. Once you install anything in the chicky hut, it becomes a structure. It's no longer a chicky hut, it's a freestanding shade structure.
Yes, we understand.
Okay. Any discussion at the board?
I have a couple comments I'd like to make.
Okay, please.
Okay, so I think what we're seeing here is the evolution of this neighborhood, because when I drove it, this house is crazy out of scale. Like, I mean, it's a monster home among these smaller homes. But at the same time, I think that that's just the future of the neighborhood. It's going to become more and more dense. So I can tell by the design of the home that they understood what setbacks were. You know, they understood what was required, because you can tell through the building of the home, because it's
Right.
built all the way out in every direction. I see 3 TVs, 2 speakers at like 5 feet high. To me, this is a willful disregard of the ULDR. And, you know, I hate to have people tear stuff down, but I mean, this is.
Okay. Any other comments, discussion? If not, I await the pleasure of a motion.
I don't want to read all that.
You don't want to make a motion? Ms. Toothaker?
I just want to state again that they didn't build the home. They purchased the home.
Okay.
So I think that's a really important point. I
They
understand
bought
what
the
you're
home
saying,
as
but they
existing.
purchased the
understand.
home that was already built in its existing location, and all they did was add the pool. So I would ask, if you are going to go in the direction of asking them to tear it down.
Disregard that comment.
Please
That's
allow us to try to meet with the neighbor. Again, it's one person that's upset. We'd be
Are
happy to do
you
that.
asking for a deferral of this matter?
I think if you're going in the direction of asking them to tear the whole structure down, then we would ask for a
I
deferral,
can't tell you
yes.
what direction we're going in.
I understand. I know I can't pull, then I would
But if
respectfully
you're
ask. for a
anticipating
deferral.
a vote that way, you might want to make the vote.
Then I would respectfully ask for a deferral, yes. Yes, I'm asking for a deferral, yes.
Is there a motion with respect to a deferral on this?
I'll make a motion that we defer,
To the next regularly scheduled board meeting?
whatever date that is, yes.
Right, the November board meeting. So I've got a motion to defer.
I'll second.
I've got a motion and a second, requires four, I'm sorry? November 9th. Mr. Spence, does this require 4 votes or 3 votes?
3.
Call the roll, please.
Mr. Mead?
No.
Mr. Maxey?
Yes.
Mr. McGinley?
Yes.
Mr. Elfman?
Yes.
Chair Nelson?
Yes.
Thank you very much.
See you back next month. Mr. Silva. And just as a disclosure, as Mr. Silva walks to the podium, I have worked with Mr. Silva in a variety of jobs over the past 30, Eric? Years.
27.
27 years. Thank you for having better math than I do.
We can round that up.
Does not affect, I have no economic interest in the outcome, and Mr. Silva is not related to me, and it does not affect my ability to hear or judge this case. So, let's go with disclosures first. Mr. Maxey? I had a brief discussion with Mr. Silva earlier today.
None?
None.
Okay, Mr. Silva, the floor is yours. Your name and address for the record, please.
Okay. Thank you, Mr. Chairman. Eric Silva, the applicant, address is 2536 Whale Harbor Lane, Fort Lauderdale, Florida. This application before you is for a zoning interpretation. I'm sorry.
Is your mic on?
Can you hear me now?
Yeah.
It's better? Okay, we'll get closer. Okay, this is for a zoning interpretation request. And before I get into the slides, I just want to say, although I have a slight disagreement with staff, they've been excellent to work with, especially Chiquila. She was very helpful with all my emails. So thank you.
You've got to say that. You used to work at the city. Come on.
Slighted.
So this is my family's application for a building permit. We've been a homeowner at this property since 1999. I'm the homeowner, but I'm also a professional planner. Been doing this for 27 years, a certified planner since 2002. I've given expert witness testimony in several zoning cases. Worked in the private sector as a planning director. When the city of Marathon first became a city in the early 2000s, I was the project manager for writing their first zoning code. I worked here in Fort Lauderdale for 3 years as a principal planner. I worked in Miami-Dade County as an assistant director responsible for zoning, plating, and community planning. And currently, I work for the city of Miramar, the director for building, planning, and zoning.
I notice you don't mention the Regional Planning Council at all. And I'm not insulted, but
There wasn't zoning work there, that's why. If there was zoning work, I would have mentioned that, yes. So the application at hand, in 2019, my family and I started working on an application to do a renovation in the front and the back of the house. We were trying to move my parents down, multi-generational family. And we worked on that for about a year with an architect. And these houses, as you know, they were built in the 50s. They have very low beams throughout the house. And it got to be very difficult. We ended up having to replace everything, basically. So we met with contractors right before the pandemic. And everybody said, just knock it down. Just knock the house down. So that's when we went back to the architect, and we designed the house before you tonight. The height of the proposed house is 24 feet, which is not 3 stories. It does include a 4 feet, 4-inch parapet. And the design of the house, we decided to design it with all concrete and steel for hurricanes. My architect said you can use wood here, you can use wood there. We said, no, we want to use concrete and steel. My wife and I went down to Key Biscayne and met with contractors to see how they're building houses down there to try and build something that was the strongest possible to deal with the strong weather events.
So the request for interpretation. Before you is the definition of a story. So I've underlined the first sentence, and this is related to the habitable area of a building, and it provides a measurement of 7.5 feet. So this measurement is very common. It shows up in a lot of places, typically for minimum housing standards, from space, light, and ventilation. It's in the Florida Building Code. You have to have 7.5 feet. It's in the city's own code, Section 9-198, the minimum ceiling height. I think it references 7 feet, but the building code's been 7.5 feet for a while, and they're all getting at the same purpose. It's to make sure you meet minimum housing standards. It has nothing to do with measuring the maximum height of a house. The sentence underlined here, for the purpose of determining height of a building. Now, as you may recall, our area of the city is the annexed area that's under the Broward County Code. So this story definition was in the Broward County Code for everything, not just for residential. So this definition applied to places of worship, gymnasiums, convention centers, hotels, everything. In this case, we're looking at it for residential, but it applied to everything in the Broward County Code. So for the purpose of determining height, acknowledges that there's a story limit because maximum height is a number of stories. There is no limit in terms of feet. There's nothing in the code that says I'm limited to a number of feet. An additional height limit of 10 feet per stories is not embedded in this definition. The purpose is not to measure the feet of a building, the number of feet of a building. The second part of that sentence, a story shall be considered to be every 10 feet of a building. Every means a group, so you need 10 feet. There's no partial measurements. It has to be 10 feet to be a story. This definition provides that formula for determining if the story maximum is exceeded. Every 10 feet. 10 feet is needed for a story, and you can't use this to say it's a limit on a story. It's on the height of a story. It's not. There's no height limit within a definition. The height limits are in a different section of the code, and the height limit here is 2 stories. So to use this code, this definition, to try to manufacture a 20-foot height limit, it's not the appropriate section of the code. Those are the development standards section of the code. It's not in the definition section of the code. And here it is. This is the section that relates to maximum height. No building or structure or part thereof shall be erected or altered to exceed a maximum height of 2 stories. There's no mention of feet. 20 feet, 4 feet, 27 feet, 2 stories. So 2 stories is the limit. You have to be at 3 stories to exceed that limit. You could be at 24 feet, you could be at 25 feet. You're still 2 stories because it's every 10 feet. Compliance cannot be determined based on feet because there's no maximum number of feet. It can only be exceeded if the building is determined to be 3 stories. So the 2 interpretations. The zoning administrator, I think it's clear in the height limit, it's 2 stories. We're limited to 2 stories. So the zoning staff has measured the building, and if it exceeds 20 feet, it exceeds the 2-story limit. They've placed a maximum height limit of 20 feet on everybody in the annexation area. And what I believe is the appropriate interpretation, yes, a building is limited to 2 stories, but a story is every 10 feet. So therefore, there's really 2 limits, 2 stories and less than 30 feet. So this is where we're located. We're in the southwest-most corner of the city, that red star there, way in the corner by 441. And this is the area. It really affects 3 neighborhoods, Lauderdale Isles, Riverland, going up Riverland Road a little bit to the north, and then Melrose Park across on the north side of Riverland. We were annexed in 2002. The zoning code was adopted in 2009, word for word. The Broward County Code was adopted, word for word. So I'm going to go through a little bit of history with the Broward County Code, as well as height limits in other cities to establish the intent and standard zoning practices. So to see what is standard in other places helps staff or applicants make an interpretation as what is standard and accepted practices in the field. What is more reasonable? What is the most likely interpretation? So back in the 50s, in 1952, When the neighborhood was built, the height limit was 35 feet. In 1996, the Broward County Code was changed to 2 stories. And within that adoption, and I've spoken with staff at Broward County, there was no record of anybody taking away any part of the buildable area of our houses. To take away 15 feet of buildable area, when they made the code amendment, there was no intent indicated anywhere from the staff or from the adopting ordinance. So then in 2020, I know there wasn't part of our code, but it is relevant because the county did not change the code in 2020 from 2 stories and 20 feet. They changed the code to 2 stories not to exceed 35 feet. So nobody has ever indicated in any of the records that there was any history in the unincorporated area for a 20-foot height limit. And there's a statement I just mentioned. No record in Broward County of ever limiting the 2 stories and 20 feet. In 2009, the city adopted Broward County's code word for word. The interpretation should remain the same as it was for over 50 years in unincorporated Broward County. And there's no city in Broward County that has a height limit of 20 feet for single-family residential. In the city of Fort Lauderdale, most of the districts are 35 feet. RS8 is 28 feet. Even the Historic Preservation District is 2 stories or 25 feet. So I went through Unicode and all the different height limits in all the cities, and you'll see that several cities have 2 stories and 30 feet, and there's none that even come close to it. Well, Coconut Creek, I think, is the closest with the 25-foot limit, but there's no mention of 20 feet anywhere. Hallandale Beach is also 2 stories and 30 feet. Hollywood, 30 feet not to exceed 2 stories. Lauderdale Lakes, 2 stories or 30 feet. Most of them are 35 feet. And you'll also notice if the intent with this code was to limit us to 2 stories and 20 feet, that's what the code would have said. The code would have said 2 stories and 20 feet, just like all these other cities say. 2 stories and 30 feet, 2 stories and 30 feet, 2 stories and 25 feet in North Lauderdale.
Mr. Silva, let me ask you a question without derailing your presentation, hopefully. I know that the 2-story height limit derives from the adoption of the existing Broward County Code post-annexation. The 20-foot, or I'm sorry, the 10-foot per floor methodology, did that come from the Broward County Code, or was that native in the city of Fort Lauderdale?
That's in the Broward County Code. That was that story definition I put up before.
Yep. A floor being every 10 feet from the exterior of the building.
Yes, the sentence for the purpose of determining the height, yes, that was from the Broward County Code. Yep.
Got it.
Here are a few more examples. Tamarac's also 2 stories and 30 feet. And I'd like to point out 2 cities in particular, West Park and Weston. So these 2 cities were incorporated in 2005 and 1996. And I think we can all, we're all familiar with Weston. There's a lot of large, nice homes in the city of Weston. And when both of those cities incorporated, which is around the time that we were annexed, they didn't adopt a 20-foot height limit. They adopted 35 feet. So in Broward County, based on the last census, there's 864,436 homes. And the area impacted by this interpretation is about 2,500 homes. And it's the only area, as you can see from the previous slide, in all of Broward County that's limited to 20 feet. 35 feet was provided when the Broward County Code was written and the homes are constructed. And this interpretation basically takes away the historic development rights of the area, the only area in the county that would be limited to 20 feet. And I did some research of other homes in the area, and there are other homes that are a little bit taller than 20 feet, and this is not a complaint about this house. I think it was reviewed correctly. On April 8th of 2015, the Board of Adjustment approved a front setback variance for a new home at 2517 Andros Lane. So this application went through the permit process. Zoning staff approved it, but they said you need a front setback variance. The elevations were in the sheets. Nobody mentioned anything about a height variance. So therefore, the staff at that time must have agreed that a story is every 10 feet. And since the mean height was less than 30 feet, it was approved at permit. There was no need to come in front of this board for a variance. And based on the measurements of that house, from the sheets that I obtained from the records department, the top of roof was about 31 feet, and to the trusses about just under 24 feet. And this home is built, and there's a picture of it right now. Very nice home in the neighborhood. There's no variance request for height. So therefore, staff must have agreed with the proposed interpretation.
Is that a valid comment to make? Is that a valid comment to make? Like,
Is that a valid comment?
yeah, like, I mean,
Part
is
of his
it,
presentation, you can believe it or not.
okay, so we can ask staff,
Yeah.
like, what that really means.
Sure.
So in summary, the height limit is 2 stories, not 20 feet. The story definition provides a formula for determining the height, and you have to have 10 feet to be a story. For over 50 years, part of unincorporated Broward County, there's no record of a 20-foot height limit. It was 35 feet when the homes were constructed. This is the only neighborhood in Broward County limited to 20 feet. Not even the city's historic preservation districts limits buildings to 20 feet. And staff agreed with the applicant's interpretation for 25017 Andrews Lane. So the requested interpretation is the height of a story is every 10 feet. Therefore, 30 feet is needed to exceed the 2-story limit. Height limit 2 stories, 10 feet is needed for a story, and it can only be exceeded with 3 stories, not 24 feet. Thank you.
So there is no, well, let me open it up for the public. I may be wrong. Anyone from the public wishing to speak? Nope. Name and address for the record, please.
Good evening. My name is Dawn Hanna. I live at 2542 Whale Harbor Lane, and
And you've been sworn in?
I'm
Were you sworn in at the
yes,
beginning
I
of the
was.
meeting?
Okay.
I will. I do.
You did.
I am their next door neighbor to the south, and I would ask you to take his interpretation and agree with it.
Okay,
Anything else?
thank you. Anything else?
I thought that was going the other way.
Come on down. I did too. Eric started looking a little nervous when she was walking up, where this was going. Sir, your name and address for the record.
Absolutely. My name is Jose Luis Barbosa. I live in 2531 Will Harbor Lane, right in front of Eric's house. And after listening to all this amazing presentation, we must agree that the interpretation of the song is correct. So we agree with it.
Anybody else? In that case, I'll close the public hearing. I've got a question for staff and a question for Mr. Silva. Mr. Silva, can you bring up the elevation drawing again? The interior elevation, the scaled elevation?
I have to hand it to him, he made his case very thoroughly. As I was reading this packet, it was very,
Okay. Can you tell me what the height is at the bottom of the concrete tie beam on the second floor?
The height at the bottom of the concrete tie beam,
Yeah. I know that it's 24 feet at the top of the structural roof slab,
Yep.
but you've got the width of the structural, or the thickness of the structural roof slab,
Yeah.
and you've got the concrete tie beams and spacers below that.
from floor to ceiling on each floor, it's 9 feet 8 inches. Probably to there, it's probably, I don't have the dimension on this sheet, but it's probably 20,
So
22
9
maybe.
feet 8 inches, so you're
Yeah.
a little under 20 feet if you
Mhm.
take that off. Got it. Can someone at staff help me reconcile what I see as two different accounting systems? I see the code that says, pursuant to the building code, a floor has to be a minimum of 7.5 feet in elevation, and that we're measuring a floor from the exterior every 10 feet. So if I do the math, and I'm a short guy, I'm not as tall as Mr. Silva. I don't need 10-foot ceilings. So if I wanted to do a 7.5-foot ceiling where I could easily fit through those doors, I could, on the interior, have 4 floors of 7.5 feet, still only hit 30 feet at the top of my elevation. But the code, if you're doing it every 10 feet, would tell me it's only a 3-story building. So how do you reconcile the two of those? Because if I've got a 3-story height limitation, but I've got 4 stories in my building because I've got 4 floors, which takes precedence, that 10-foot exterior measurement or the actual height of the floors?
We actually have to consider both. So one part of the code is stating that there's a maximum of 2 stories. And contrary to what was stated earlier, we do often use multiple sections of code to determine one thing. They're not mutually exclusive. The
Well,
other
in this
section
case,
of
I
code,
think they would be. You'd have 4 actual 7.5-foot floors, but your measurement would only say it's 3. From
the
exterior.
7.5 foot is a minimum.
On a floor, didn't it say you have to have 7.5 clear in a floor, not outside?
Mike, please. Doesn't it say you've got to have 7.5 clear?
Doesn't it? I'm sorry, I read it, that you have to have 7.5
Again,
feet clear.
Dwayne Spence,
inside
Assistant
to
City-
end up to be a floor.
Right.
Nothing to do with outside, inside.
Exactly.
You may have 4 feet of ventilation space between the ceiling and the floor.
Right, so when do you count it as a floor?
So,
Because they're 2 different things.
as Bert said, 7.5 feet is a clear ceiling height which is required. You can minimum ceiling height as per
For the
Florida
Florida
Building
Building
Code, as per
Code,
this
right.
code. The 2.5 feet is for ductwork, AC trusses or whatever. So that's where they are getting up to. That was, to me, that was the intention when it was written, maximum of 10 foot, where 7.5 foot has to be clear and you have 2.5 foot to put trusses, ductwork or whatever.
That seems
So
crazy.
to be a little bit more precise, Dwayne Spence, Assistant City Attorney, the definition of story speaks to habitable area having a clearance between floor and ceiling of 7.5 feet.
Minimum.
And that's the minimum clearance for habitable area to be considered a story.
Got it.
And then the code goes on to state that for the purposes of measuring,
Floors.
for the purposes of determining the height of the building, you're going to consider every 10 feet from the exterior of the building.
Right. From where to where?
From the first floor level is the beginning of the measurement.
Right, to
And then it's every 10
Line.
feet is considered a
roof line, edge of the roof line, top of the ceiling.
Top,
What?
top of the roof line.
top of the roof line, correct?
The roof, no, the roof line, not the,
so in the,
like
in
he has
the,
a flat roof, which makes it a little easier, and it
Right.
also has a lounge.
in the annexed area, flat roofs are measured to the top of the roof deck. For a pitched roof, it's the mean roof height.
Height of building is also defined in the
Defined.
code.
I thought we had
About-
just finished talking when we were talking about the chickies, that roof height is,
That's in the city ULDR.
That's the city
This is-
ULDR. So the height of the building, as defined in the code, is the vertical distance from the established grade at the center of the front of the building to the highest point of the roof surface for a flat roof, or to the deck line for a mansard roof, and to the mid-height level between the eaves and ridge of gable hip
right.
roofs. So it's a defined measurement and the annexed areas portion
Got
of
it.
the code.
I'm having a hard time figuring out, someone with a pitched roof house could end up in a 2-story area where if you've got a steep enough pitch, you may not be able to get your second story in.
And that's why when I speak to people on a daily basis, they all choose to build a flat roofed home. So they don't lose that height.
Mr. Chair, I just have a quick, I just have a question. There is nowhere in the code that specifically says that this is the maximum height for this area, like in feet.
Code Section 47-39.86D states that no building structure or part thereof shall be erected or altered to exceed the maximum height of 2 stories.
Understood, but there's nothing that says anything about feet in that. It just says, that's it.
And then
That's
in
all
the
it says.
definition of what story is, it says you measure it to be every 10 feet.
I mean, but working in the development community, there is no such thing as a standard story. I mean, how can you sit
So
here
the
and tell me that
difficulty
10
here-
10 feet is what a story is? I can look at a building and I can see it has 2 stories. I don't need you to, I don't need to be told that it's, defined. It needs to have a maximum height limit, right?
So
And defined in feet.
Correct. So the issue here is that when this portion of the city was annexed, the city commission made a commitment to the community to continue to have the unique character and nature of this community. They worked with the community to adopt particular code sections for the community. Now, we weren't necessarily a part of that deliberation and that process, but we're familiar with the processes that the city undergoes when we do code changes.
Right.
And so this is the code that they agreed upon in the early 2000s and has been adopted. And if we're looking for clarity, the preference would be to seek another amendment through a similar process.
Got it, but Mr. Spence, at the time they did that, this zoning district, when they brought it in, had a maximum 2-story height limitation and a actual footage height limitation, didn't it?
It did not.
No.
The code adopted was the exact language out of the Broward County
There
Code.
wasn't a 35-foot.
No, sir.
Mr.
And so that,
Silva's
and that,
presentation seems
correct.
to make it sound like there was, no, I'm sorry, that was a subsequent modification to the county code.
With intent.
What?
It had intent.
So in, the presentation presented evidence of a prior code. I think he references a 1952 code. I don't have that document to confirm the validity of that. And then he references a subsequent amendment that Broward County did to, I assume, address this issue and amending their code subsequent to the annexation. But we are left with the code that was negotiated with the residents at that time and what was the current code for Broward County.
Do we have any idea when that was? When that original,
Annexation was,
October of 2005.
yeah.
when this code was, like, they just, not adopted,
When it was
like, when they
adopted,
decided.
2005
Yeah,
of
but
October.
when, but it was adopted from an older
February
code, right?
26th.
Or that's when they decided was in 2005? Okay. You follow what I'm trying to say? Like, if this was a code that was generated in like the 50s, I would see where, okay, well, the neighborhood is growing and the houses are changing. But if they made the rule in 2005,
No, actually, this code was adopted in 2009.
Right, but the area was annexed in.
In 2005, correct.
but you follow the question I have, which is when was that original kind of section of the code generated? To try to give me a sense of like when it was, because if the neighborhood got together and decided
Equally
yesterday.
to the point, what's the height of the existing county-approved houses before it was annexed? Because there's lots of houses in this neighborhood that were built pre-annexation. Are they all at 20 feet or less?
I think so. I'm not sure, but I think so. They were following this code. And since we have annexed it, we try to keep it to the limits
Same.
what we have.
To
Yes.
respect it, that makes sense.
And
So that's part of the issue here. Prior to the actual annexation process, the city adopted Resolution 02-28, and it recognized, and I'll just read in out of Section 2(1)B, that if any existing building or structures do not meet any Broward County Code or City of Fort Lauderdale zoning code, the city will work with the Greater Riverland Road area residents to develop zoning codes unique to the area for the purposes of an ordinance that would allow existing buildings or structures to exist in compliance. And that's what we believe that the 2009 process
Did.
was
As
intended
it
to
did in
do.
all the other annexed areas, piece by piece.
Correct.
From a modern construction perspective, a 10-foot floor-to-floor is unrealistic. And so I mean, it's theoretically possible, but no one's going to want that. And while 12-foot floor-to-floor does represent a luxurious dimension, it's not unheard of. And so to request a 12-foot floor-to-floor does seem reasonable within the context of a modern built home.
Modern structure, especially a concrete slab structure.
Mr. Chair, the one thing I would say to staff is that, again, this leaves it completely to interpretation. If I was developing this site, I would hire lawyers to basically allow me to build 2 stories at any height, because that basically doesn't say that I'm limited at all at a height restriction. I understand you're trying to take 2 parts of the code and match them together, but that, you really start getting into some murky territory doing
I
that.
would have been happier to see this as a variance application.
Right.
And I had asked the applicant, go for both, and
I hear you.
He also showed other parts of the city that have maximum height in feet, right? I mean, that was.
Well, that's not, and as we indicated, because this is an annex area, other parts of the city is not relevant to this particular situation.
Understood, but I'm just saying.
The applicant and city staff agree that both code sections work together, that the 10 feet is the height of stories for the purposes of measuring the distance.
And my
But we
purpose of bringing this
disagree.
up is to say that maybe the staff should make a maximum height instead of using the 2 different sections of code. Maybe there should just be an amendment that says this is the height restriction on a 2-story.
And we would agree with you, and that's what we believe the appropriate process for the annex area is for us to do a public outreach and bring this to the community and say, where is it that you would like your heights to be?
Where is height?
exactly.
But the concern with the interpretation is allowing 2-story to be anywhere between 30 feet, if that wasn't the intention. What does that make a 1-story building?
Right, but I don't know that your argument that the interpretation that 10 feet was what the community wanted is accurate as well. I mean, you're making that assumption, but that's not what you pulled from their code. What you pulled from their code is that it's no more than 2 stories.
That's inaccurate.
Right.
Because it specifically says that the story is measured from floor to ceiling. Specifically, floor to ceiling is the 10-foot measurement. It's exact. It isn't a guess, it's not an assumption. It specifically says that the measurement for 1 story is taken from the
10 feet
floor
building
to the ceiling
plus floor
of that
level.
story.
But in this case, that measurement would be under 10 feet,
It wouldn't,
right?
it wouldn't for typical construction. When you have a 2-story home, you have floor to ceiling,
Right.
and then you have a floor joist that's typically 2 foot to run all of your utilities through. That's the 10 feet. Then you have another 8-foot story on top of that from floor to ceiling, and then you have the utilities running in the attic.
So
That's
so
where
the-
that comes from, and
so
that's
the-
general
Doesn't have an
construction.
actual height, it's got a story limitation.
It has a story limitation, and and it's this
And a way of
particular
determining
sentence out of what the definition of story is the issue that says, for the purposes of determining the height of the building, a
Every
story
10 feet.
shall be considered every 10 feet of building height from the first floor level measured from the exterior elevation.
Except the code also says, unless there's 7.5 feet clear, it can't be a floor, right?
Well, the distinction of for the purposes of measurement
I-
kind
I'm
of puts
curious, so
that to the side.
What's this extra 2.5 feet that's sitting there? Because it's certainly not a third
That's,
floor. Because
that's
it's
what
not
we just
7.5
said, it's
feet.
Correct,
it's the
that's-
area where the utilities are built into the house.
Well,
You have to
got it,
run
but the
ductwork.
height limitation is a 2-story height limitation. It's not a 20-foot height limitation. The code doesn't say that. Code says it's a 2-story height limitation, and there's another portion of the code that says how we measure stories. And it tells us 2 things. Exterior every 10 feet. But you can't be a floor unless you've got 7.5 feet clear.
Correct.
So once he hits 20 feet, what's that extra 2.5 feet? Because it's certainly not a floor, because it's not 7.5 feet clear. So it can't, by definition, be a floor.
Oh, no.
Just one.
So I don't know what it is, but I don't see how it exceeds the 2-story, 2-floor height maximum, requirement or cap, because it can't be a floor. And I think that's where you were going, except you've got 10 feet and I've got 7.5 feet as my trigger.
Excuse me, Mr. Chair, can I just say one thing? It was mentioned that there's a 10-foot limit. It's not a 10-foot limit in the story definition. It says every 10 feet of building is needed. So the definition provides a formula to determine how many stories you have. It's not a 10-foot limit. It says every 10 feet of building. So if I have 24 feet, that's still 2 stories, because I need every 10 feet. Every means a group of things. I need every 10 feet to get a story.
What's our action here?
I'm sorry?
What's our action on this?
Our action would be to reverse the interpretation or affirm the interpretation of city staff.
And is there ancillary fallout associated with that? Like if we decide to go against their interpretation, does that?
That becomes the interpretation
Right.
of how we apply this code section throughout the annex areas.
Right.
And I would ask,
That's why I would have been much happier if this was a variance.
There's a ripple happening here.
Yeah.
is the board going to determine what the height's going to be? Are you going to say it's going to be 10-foot stories, 12-foot stories?
No, because we haven't gotten there yet. The only thing I know sitting here right now is I don't know what to make with that couple of feet above 20 feet, because it can't be a story, because it doesn't meet the minimum requirements for a story. So we've got 3 choices as I see it here. We can affirm staff's interpretation because they've measured every 10 feet and there's something above 10 feet. We don't know what it is yet, but there's something above 20 feet there. And so it exceeds the 2-story height.
It's not
maximum.
compliant.
We can reverse their interpretation, hopefully giving enough specific, site-specific facts that we don't set a problematic precedence. Or we can suggest to the applicant that maybe he comes back as a variance
Does he
rather than an interpretation.
So he has to come back, is what you're
If he's
saying.
got to, well, I know those are the 3 alternatives.
There's no variance tonight. Like there's no way
variance.
he could
We can't convert it.
magically.
Right.
Okay.
It's not a 2-point conversion. We can't magically convert it to a variance. Not
tried.
advertised correctly, not noticed
That makes
correctly. You're gonna draw something, aren't you? Can you draw it where I can see it?
No, he did. That's.
I'm actually gonna ask the board for a few seconds to step off the dais and take a closer look at that, and then we'll come back to the dais.
I can see it. It's
Because I
beautiful.
can't see that from here. Can't see that.
And if I can, to add a little bit more information, it seems like one place that a lot of the confusion is coming is in the part of the definition or the determination for story where it talks about habitable area at 7.5 feet, excuse me.
Yeah.
Gentlemen, I'll need you to be on the record.
microphone.
Your conversation.
Could you be louder, please? Could you be louder?
Could you be more like yourself?
Yeah, exactly. No, the idea of a 7.5 ceiling is ridiculousness. Like
That's safety. It's supposed to be life safety.
Chair, and I do agree. I mean, I have been telling the applicant but if you prefer, send a communicate to the city commission to change the code,
Well, I'm going to do two things, and I'm sorry to do this in the middle. I'm going to actually ask for a 5-minute recess because I do need to hit the board member's bathroom.
Okay.
But while we're gone, Mr. Silva, you might want to think about whether or not you want to defer this and think about whether you want to come back as a variance rather than a code interpretation. Understanding that a variance requires you to accept that the code is correct. And I'm going to adjourn us for 5 minutes. So if I see you haunting the mic stand.
Yes, Mr. Chairman, I just wanted to make one thing, one statement. Actually, the noticing that went out, there is another neighbor here. Is it okay if he speaks for a minute? He received the notice in the mail. Okay.
I came tonight to, actually for Stennis Gullo, Gullo, 2555 Tortugas Lane. I'm right across the canal. I came tonight just to listen because I'm going to be in the same boat. Right now, I'm with an architect, and we're coming in at 22 feet with everything. So I'm just, if we're going to have to do variances, we're going to be, a lot of us coming to present to you for those variances. So, thank you.
Thank you.
And I'm sorry, that was the owner?
What?
Was that the owner of the, no. Who
No,
did
that
he
was a
represent?
lot across the canal. He was just listening because he's coming in with plans that have the same exact height. A
Okay,
22
good.
foot height.
So he was a homeowner.
Right.
Okay.
And just wanted to mention one other thing. When you say a ripple effect, and is it going to impact other homes? Yes, it is going to, but it's going to make them consistent with the rest of the county, which is 35 feet, 30 feet. It's not going to, make it out of whack with anything else that's going on in the county and other neighborhoods. This is the only area.
I don't
that's
know if
20
that's
feet.
within our jurisdiction, though, is it, to make those types of decisions?
So I think you guys were walking us through the 7.5 foot, 2.5 foot to add up to 10. That, of course, that math, at least in my mind, only works when you've got a 7.5 foot high room, and nobody seems to be building those. I've got an older house, build those, mine's 7.5 foot. I'm not seeing any new houses that build to that ceiling height.
And if I could add a little bit of some more clarification to that. This code is, the definitions that we're talking about apply to all different types of buildings. It's not specific to a residence, which is what we're applying it to right now. When they defined a story in the code, they're trying to limit it to a place that has a human occupant in it, therefore habitable space. That's why they say 7.5 feet.
Minimum.
Because it has to be considered a real story that's habitable and meets code. It can't be 4 feet, it can't be 3 feet. It has to be at least 7.5 feet if we're going to discuss a story. And that could apply, as I said, to all different types of buildings, not just a residence. For purposes of this code, it seems crystal clear. It says 2 stories. It says a story is 10 feet. It tells you exactly how to measure a story. It also allows up to 5 feet of additional height above the maximum of 2 stories. I can't find any
Like the parapet
vagueness.
walls, or they can go about 20 feet, they can
Got it. But not to the roof line, just the parapet wall.
use the parapet.
And if I agree that this may not be the best code, but there are other ways to approach changing the code, modifying it, getting the neighbors to agree to a meeting. But we're in charge of enforcing the code as it is written.
It's written.
And that's what we're doing.
Yep, I hear you.
So if we, let's just say we did dispute the interpretation, through that, are we setting the new height based on his house?
We could be if we just say we disagree with staff's interpretation,
And then leave it at
as opposed to disagreeing with them on certain fairly specific aspects of how this is measured, such as the thickness of the roof slab coming off, because this is a structure this structure is about as different from my 60s style ranch house construction as you can get.
No, this is commercial construction, which isn't a bad thing, but
Right.
but it is.
Right, but the while it's a flat roof, that flat roof is a couple of feet thick. on
Well, I
this.
mean, it's 4 to 5 inches, but you have a couple feet of structure.
Then the joist on top of it, or below it.
Right,
So-
but you can design stuff too, where, I mean, I'm not designing your house for you, but not every, new modern construction, a lot of stuff is in the walls, you have smaller closets, you have ceiling.
In the mic, please.
Sorry,
Yeah.
I'm not architecting, but a lot of construction, you have lower rooms, bathrooms, where you have your stuff, it feeds in through walls, they don't have the same,
Floor to floor.
floor to floor, and you use that space.
Well, here's where I'm troubled. I know that we measure a floor every 10 feet from the exterior. I know that's in the code. I just don't know what to call the extra. Is it 2.5 feet or 4 feet here? 2.5 feet? What's the total top of the roof height?
7.5 plus 2.5.
What?
Max.
I don't know what to call that extra 2.5 feet
Plenum.
because it can't be a floor.
Plenum.
What?
It's plenum is the name for it.
For utility area, plenum.
But that's not a floor. It's a plenum, it's an area, it's something above that 20-foot height. That's not a third floor, and this zoning code
It's
says.
within the 10-foot height. It's
What?
within the 10-foot. That plenum's within his.
I think he's talking about something different. I'm sorry.
I'm talking about something completely different.
Yeah.
So if we're measuring every 10 feet for a story, at a certain point, before we hit the top of the roof and stop measuring, we
Remainder.
exceed 20 feet. But we don't exceed 27.5, so whatever is above that 20 feet can't be another story because it doesn't meet the minimum enclosed space height requirements for another story. There's no height restriction in this district, so I can't say it's 35
Doesn't it say
feet.
2/3? Doesn't it say 2/3? It's a maximum of 2/3 height for the non-floor.
If you want to put another floor in there, habitable space, it can't be more than 2/3 of the lower space for it to not be considered a floor. But this, by the definition of a floor in a residential structure has to have clear minimum space between floor and ceiling of 7.5 feet. And this doesn't. Whatever is above 20 feet doesn't have that 7.5 feet of clear. So it can't be a floor.
Right, it's like attic space.
What?
It's like attic space.
Well, but that's not a third floor, so it doesn't exceed the 2-floor maximum. That's my problem. Sorry.
I don't know. I don't know what the solution is. That's what I'm having.
I don't,
If
I
I
don't know
may-
the solution.
Again, I think the solution is to establish a maximum height and.
But that's not where,
that's-
we don't belong to that neighborhood. We don't know
No,
what's
I
going
understand
on.
that, but that's what needs to be
Nor
put
do
into
we
the
have the
code.
ability to do
No, I
that.
know, that's what needs to be put into the code, and until that's put into the code, we cannot deny really any height limits for these stories. That would be my interpretation, because the code is not clear enough that you can actually deny any story for height.
That's a take. What do you think about
Excuse
that?
me, not any maximum height of the building as long as it's 2 stories,
That you
based
can't
on how I'm
deny
reading it.
because of that.
I don't know. I don't know.
Excuse me, the code that we're talking about, the way that it defines the maximum height of a building is by adding 10 foot per floor, which is total of 20, and another 5 for the parapet. That's how it's defined, and that's how we've been measuring it.
Right.
If you were to, for some reason, go along with the other interpretation that 10 foot is not the definition of a height of a story, then there is no definition for the height of a story, and a building could be built 100 feet tall. The only way that this code defines a maximum height of a building is by the 10 foot plus the 10 foot plus the 5 foot. And as far as the 7.5 foot question and the area above that, the height, it doesn't address that.
Things they teach you in law school.
It doesn't.
That drafters are assumed to be intelligent people. And if they have the ability to say something clearly in one section of the code, 35-foot height restriction, and fail to say it in another part of the code, that can't be accidental, that has to be intentional. So there's no maximum height in this district. You're right. We could go from the sublime to the ridiculous, and somebody could have a 100-foot single-story house. But that's not what's happening here. What's happening here is more modern building construction, and it doesn't seem to meet the definition, at least in my mind, of a third floor. I don't know what it is, but it's not a third floor because a floor is a minimum of 7.5 feet of habitable space. That's where I've got a problem.
I believe
Which could
that the
be
way that
solved if the applicant came in back as a variance, but that's besides the point.
Right, but it doesn't say less than 3 feet. It says no more
He-
than 2 stories.
I believe what that
It
is,
says no more than 2 stories.
Right. So where's the third story?
It doesn't say anything about a 3rd story. It says you cannot exceed 2 stories.
Right, so where's the third story? Where's the third story? Because by definition, it can't be a story. So
Yeah.
by definition, he's not exceeding 2 stories.
Yeah, I mean, but when you do things like occupancy and parking counts and things like that, 5.1 spaces is 6 spaces.
I hear you. Well, luckily, I don't get to make motions sitting in this chair. So we've had a presentation, we've heard from the public. It's in front of this board, unless, of course, Mr. Silva wants to get up and say, you know, I'd like to defer this and come back as a variance. But that doesn't look like that's happening, so I'm gonna look to my left and my right for.
I'll do the motion, but I just need to know what section of, is this is not the ULDR, this is, okay, it is the ULDR?
Yes,
Okay.
it is.
All right. Mr. Chair, I'd like to make a motion for case number PLN BOA 2207003 to affirm the interpretation as it meets the minimum requirements set forth in the ULDR, or meets the,
Or is it
or it meets the
interpretation
requirements
consistent
set
with
forth in the,
requirements?
yeah, just meets the requirements.
I've got a motion, is there a second?
Second?
I've got a motion and a second. Any discussion before we call the roll?
Could you just explain what you're saying?
Yeah.
He's affirming.
So
the staff
I'm
decision.
saying, I'm agreeing with city,
Right.
the motion is to agree with city staff.
We've got a
right?
motion
So if you
and a
don't agree
second.
with city staff's interpretation, you have to vote no.
Any other discussion before we call the roll? Call the roll, please.
Mr. Mead?
Agree? Yes?
Yes, okay.
Yes. Mr. Maxey?
No.
Mr. McGinley?
No?
Mr. Elfman?
Yes.
Chair Nelson?
No. Motion fails.
2 to 3.
Motion fails.
So kind of leaves me in an awkward position because the validity of any order, and in the case of an interpretation, you're either affirming staff's decision or you're reversing it. And the failure of the affirming does not
No man's land.
necessarily
Right.
create a situation where you've reversed staff's interpretation. Because in order to have that order.
No,
accepted-
correct. I think it stands, I think it stands.
We affirmed.
Well, you need 4 votes to affirm.
Okay.
You need 4
You
votes
have
to-
not affirmed, you have not affirmed. Okay.
We haven't affirmed, so it's just kind of floating out there, unless somebody wants to make another motion. Right, I've got the same expression you do. This is one of those cases where you're in a no man's land if you don't have 4 votes, one way or the other,
Yep.
or no woman's land.
Okay, I just want to be clear for the record, not necessarily calling you all to do another
Making a
action.
motion.
I'm just wanting the applicant to be clear that the interpretation has not been reversed due to the failure of
Right.
that motion.
And the request for relief was a reversal. That request was not granted. I don't know that we need an affirmance by positive vote. And if you want, let's do this just so we're abundantly clear. Can I have a motion in the reverse or in the alternative?
So you're asking for a motion to dispute the.
To reverse staff's
Reverse.
decision with respect to the height limitation.
It's number 4. I'd like to make a motion on case PLN BOA 2207003 to reverse the staff decision relative to building height.
Height.
Reference to building height.
Building height, correct?
So I've got a motion to reverse staff's decision. Is there a second?
Second.
I've got a motion and a second. In order for the reversal to be successful, it requires 4 votes in the affirmative. Yes to reverse, no to not reverse. Can we call the roll?
Mr. Maxey?
No.
Mr. McGinley?
Yes.
Mr. Elfman?
Hang on 1 second.
Hold on.
This is to reverse, now I'm yes to reverse staff's decision. No.
No? Okay. Mr. Mead?
No.
And Chair Nelson?
Yes. Motion fails. So now at least you have a clear motion on the reversal,
Thank you.
which is, I guess, had I thought more about it, how we should have done it the first way. Mr. Silva, thank you for an excellent presentation.
That was incredibly well thought out. He did. I don't know if you read that package. He dissected that thing every which way.
All right, let's call case number, Andy, you there? Good. Case number 2208-0007, Bernadette Indre and John Palmisano, represented by Andrew Shine. Let's go for disclosures first.
I don't have a 7.
What? Do you not have the agenda?
The same packages or the same numbers. I have 1 and 5.
Because these were in the previous packet that you're.
Yeah.
Because October
that's-
12th.
Yeah, no, that's the issue.
Yeah.
Let's go for disclosures, if we can.
No disclosure, Chair.
No.
None for me.
Spoke with counsel.
Spoke with counsel.
I feel special now. It was a tough one tonight,
A bit.
man.
What?
Tough one.
Yep. Mr. Shine, the floor is yours.
Good evening, Chair, members of the board. Andrew Shine with Lockery and Chakas, here representing the property owner. The property owners are John Palmisano and Bernadette Indre, who are in the audience with us tonight. This is an aerial of the property. It's located in the Coral Ridge Isles area. It's one of a handful of properties in the city. There are some in this area, but a handful of properties in the city that are on these odd pie-shaped lots at the end of canals. We have a lot of canals in the city, but really only Coral Ridge Isles and Citrus Isles in the Croissant Park neighborhood have these corner lot areas. The other ones, like Lauderdale Isles, Seven Isles, those don't have these odd corner-shaped lots. And this is a close-up of the property. We're here tonight to request a tiki hut variance. Now, I know we heard one of these tonight. This one has significantly different circumstances that led up to it, and different requests as well. We are requesting a variance to allow the structure itself, which is where the columns are, to be 4.7 feet from both the rear and the side property line, and 2.7 feet to the thatching. So if you look at a tiki, it has the thatching that hangs over. So it's not really structural, but we're adding that in here to be safe on that. We're also requesting a variance for the size. The size is about 297.54 feet within the columns and 451 or so if you include the thatching that hangs around it. As for the variance criteria, this is a fairly unique shaped lot. It tapers on the west side, as you can see. The front of this lot is 110 feet in width, and the back is 70. So it tapers over 40 feet going on the west side, leaving a significant deficiency of room to do much in the backyard here. So one, the special condition is the lot shape. Two is this house was built in 1957 with a major remodel in 1968. It's an old house, and it was built with non-conforming rear yard setbacks. So normally the rear yard setback requirement is 25 feet. We're a little bit less than 25 feet, so it's non-conforming right now. You are allowed to have tiki huts in the rear yard setback. It just has to be in this area 10 feet from, it says from the waterway as defined in a certain code section. I did put in the narrative that cross-reference to the code section defining a waterway is not doesn't reference the correct section, but regardless, the waterway here is measured at the property line, not at the actual dock where the water is to the north of the dock. So we're requesting the variance to have it from the property line, which is where it's measured from. The second criteria is is that there are substantial property rights that others get to enjoy. And I elaborated this on this in the narrative. I won't go too far into detail now, but predictability is one of the property rights that the city actually adopted into the comprehensive plan a couple years ago. And things like incorrect cross-references on how to define distance from a waterway, that limits the predictability and the property right of the owner to know what they're getting into. And the second is a property right that's also been enshrined in the comprehensive plan, and that's the ability for owners to improve their own property for personal use. And we'll get into why that's relevant on the next slide. As for the hardship, besides the unique lot shape and the non-conforming setbacks, which frankly can stand on their own as hardships, the owners here had two additional ones. The first is a reliance on the contractor, and there was discussion in previous talks about whether chicky huts and tiki huts need to be permitted, if it's done by the Seminoles or Miccosukees. This one was done by a company called Dan the Tiki Man. They're based out of Homestead. And I pulled the excerpt on the left from their website. I pulled that today. It's been there. I looked back in old versions of this website. It's been there since this hut was built. Where they say, we know the laws in your neighborhood. We take care of permitting and authentication for you. An unlicensed contractor may save you a few $100s, only wind up costing you many thousands later. And I actually had experience. You can take this as evidence or not, but I had experience with Dan the Tiki Man. They did a tiki hut in my backyard. And they say they handle permitting. They say you're good to go. They say we'll get it authenticated by the Seminoles. You're fine. Me, in my personal position, I went down to the building department and found out if, I had to verify as a homeowner, and I couldn't trust the contractor. And that's what happened here. Most people are not land use attorneys. That's just
Thank God.
That's just the case. Agreed, or environmental attorneys as well. But reliance on the contractor here, particularly when they say, we're pulling permits for you, you got your permit, we're doing this, we're getting authenticated by the Seminoles, you're fine. Only to come out later, about a year after it was built, that was not the case, even though they paid for things like that. So reliance on the contractor is a third separate hardship, which again, frankly, can stand on its own. But the reason that the owners got the tiki hut is their son Nico, who's turning 3 in December, has a skin condition. They're going to pediatricians to determine what it is, but he's essentially allergic to the sun. And there was nowhere in the backyard for you to take him out. He blisters, gets hives, just being out in the sun for a few minutes. So they needed some type of shade back there. And being in South Florida, the tiki hut is a common choice, not just throughout the city, but on this stretch of the canal as well. The last criteria is that it's a minimum variance necessary. This is a rough drawing of the setbacks and where you can and cannot put a tiki hut. The red is everywhere where a freestanding shade structure cannot be. And that's a lot due to the limiting nature of the property. One is those odd side property lines that jog in over 40 feet. And the other is the non-conforming setbacks of the property itself. It really limits what you can do at all in the backyard. And again, that's uncommon with the lot shape and just being an old house on a unique lot. The white area there next to the house is the only place that a shade structure can be. However, there's no room to have a reasonable shade structure there, let alone a tiki hut where you have posts, you have overhangs, you have the actual house that you have to deal with. You have areas around the pool that are required for child-proofing, for fences and things like that. So there's no reasonable area to even have a shade structure back here without it being essentially where it is. So we do believe that this is also the minimum variance necessary in this case. These are photos of the back of the property. The first one is looking east down the waterway. You can see it's not really blocking anyone's views. Everyone has a boat here. Doesn't affect anyone to the east. To the west, the tiki is flush with where the fence line would go if it was extended. So it's not blocking the neighbor to the west either. Though we do have the neighbor immediately to the west in the audience. Stefan is here. Thank you for attending. And he is in full support of this application, but he's available for questions if you want. And lastly is support. We did reach out to a lot of neighbors. All the ones in green highlighted here have provided support letters that I can pass out. Thank you. They are all in support. We didn't hear anything about any neighbors objecting, at least to the ones that we spoke to. Some we couldn't reach because they're either out of the country or just weren't available. But everyone who was immediately could possibly be impacted by this has provided a letter of support in this case. So thank you for letting us present tonight. I'm sorry it's a little bit of a late night. But we have a lot of hardships here, multiple hardships that can really stand on their own. And it's not an egregious request given the actual shape of the lot and the uniqueness here.
Thank you.
All right, thank you, Mr. Shine. Any questions from the board?
I just want, for the record,
Yes.
I did do a drive-by this. This is the
Okay.
tiki hut I did the drive-by.
Okay. Mr. Shine, when we talk about the minimum variance necessary, because there's two different things going on. One, we've got a chickie, and is this just going to be used as a chickie, or is it also going to be an outdoor kitchen?
It's already built. It was already built. There are some kitchen things there. I don't think you have a full wet sink or. I can speak for him. Cabinets. It's not a full
Okay.
kitchen.
That's substantially in excess of the square footage allowed and also in the setback. So when we talk about the minimum variance necessary, and I understand that it's in place, is there any ability to rework the chickie and make it smaller and still achieve the goal, but make it closer to the square footage and make it closer to the setbacks?
At this point, the structural columns are already 4 feet underground with concrete, so doing that is tough. But what I will say, and I don't know if staff will agree with me on this, I don't want to do an interpretation case for this, but the way the code actually reads is that the portion in the rear yard is limited to 200 feet. So the rear yard, again, this happens to be the entire rear yard because it's 25 feet and it was built non-conforming.
Right.
But truly, it's only the portion that's within the rear yard is limited to 200 square feet. At this point, it's not really possible without tearing the entire thing down to do that. Again, you have 4 feet down in the ground of structural concrete wood columns. So at this point, no. But again, we have the support of all of the neighbors on this one, and nobody has really asked us to limit it down.
Yeah. When did they buy the house?
They bought the house in 2019.
When did they have the kid?
When was he born? I mean, I could do the math. He's turning 3 in December of 2022.
So right about that.
They also had him in December 19th, 2019. December 19th, 2019.
Yep.
You just renovated the house?
They did do some renovations. The front of it, you drove by it. It's a beautiful looking house. So yes, they did renovations, and they got the tiki built last year. So it wasn't an immediate thing. A lot of it had to do with their son being completely unable to use the backyard.
The pool and the backyard here before you did the tiki, or is that all done, the whole backyard done together?
Was the pool done?
Can you please so that you can speak in the mic?
I'll ask you.
That's fine. The pool was pre-existing before them, so they couldn't remove that and build a shade structure on top of what what was there.
Okay. Let me open this up actually for public comment. Any member of the public wishing to speak on this, now's your chance. If not, I'll close the public hearing. Let's close the public hearing. Any other questions from the board?
So what is the current state of the permit for this cheeky hut? Like, is it a non-permit, is this a non-permitted cheeky hut?
So we would,
Is this one of those that is built by the,
Well, it depends on what's inside of it. And I think as Bert had said before, the cheeky itself does not require a building permit, but the minute you start putting stuff in it, like electricity, it becomes,
Yeah.
yeah.
well, what,
Just for FYI, in general, we get a lot of people coming and asking us that, and I don't know what's out there, but the cheeky hut contractors tell them they don't need a permit. It happens a lot. And, we get all the time, if some owners do come and ask us, we said, you do, if it's a zoning permit, it not be a structural permit, it would be just a zoning permit, you still need it. But it does happen, I have seen it done in my almost 22 plus years with the city. People later on, they come to us and said, we were told, by the contractor, it's not required.
the reason I ask is, I'm wondering if there's any opportunity for the owner to go back to the contractor of the tiki
Have
hut
them rebuild
and
it in
insist
order
them,
to
yeah,
be
because,
conforming.
I hate to put the burden on the owner, but at the same time, if that contract is still fresh enough to where you do have that option, I think that option needs to be explored.
do you mind if I speak
Yeah.
here? I think in ordinary circumstances, that would be a pretty good and reasonable request. The problem with this is we would still need a variance because there's really no great buildable area.
But it would
Right.
be the
If you brought it
minimum,
From 17.1 by 17.1 down to 14, I think it's 14.5 by 14.5, you don't need a square footage variance. And if you set the lower right corner where it is and shrink the other two sides, then you need much less of a setback variance.
Possibly depending on where the structural columns themselves would need to go. You have pool equipment there. You have other things underground there, maybe possibly utilities. So I can't guarantee that that would be the case.
Yeah.
I can't guarantee. It's a big unknown. I definitely understand the concept. For this, I don't know how necessary that would be given the request, but.
I hear you. Motion?
I'd like to make on, let me get the case number, on case number PLN BOA 22080007. I'd like to make a motion to approve both variances. The one requesting a variance to permit an approximately 451 square foot thatched overhang. Then that would be in regards to the freestanding shade structure portion. And then I would also, in that same motion, I'd like to approve the table of dimensional requirement variance for the freestanding shade structure at a setback of 2.7 feet as they meet the.
Because it meets the requirements for
requirements of the
variance
UDO.
under the code. I've got a motion for approval of the variance. Is there a second?
Second.
Got a motion and a second. Any discussion prior to the roll?
I have one item of discussion.
What?
Actually, maybe an amendment to the motion, if it's going to be considered, is the same stipulation we spoke about before, that if it was going to be.
Mike?
Sorry, I thought I was in. If it was going to be approved, a stipulation that if it ever had to be replaced, that it be replaced within the current code.
Within the 200 square foot? Okay.
But isn't that implied?
What?
Isn't that implied?
No, once if you got a variance, you got a variance.
Oh, wow, and they could, I think that's a great point.
Okay, so there's a proposed modification. Do you accept the modification?
Oh, is it that easy? Yes, I do, I do accept.
It is
Elfman's
surprisingly
modification.
that easy. Yes.
I thought I was gonna have to make the whole thing again.
No, we wouldn't do that to you. So we've got a motion as modified to require, upon casualty, that the rebuild be limited to 200 square feet. But no limitation on the side yard variance. So I've got a motion and a second. Let's call the roll.
Mr. McGinley,
Yes.
Mr. Elfman,
Yes.
Mr. Mead,
Yes.
I'm sorry, what?
Yes.
Yes?
Mr. Maxey,
Yes.
Chair
No,
Nelson.
why not make it unanimous?
Thank you all.
5-0.
This is the hardest night I've had.
Okay. We've got, number one, any communications to the city?
Great job.
I'm going to suggest one, is that we ask the city to take a look at the height and zoning requirements in the annexed areas to more accurately reflect current building construction techniques so that we don't have the same situation as the last time.
Do I second that, or is that just a?
What? We need that as a motion, which I'll make as a motion, irrespective of sitting in the chair, if I have a second.
Second.
All in favor?
Aye.
Aye.
All right.
Can I amend to ask for a specific height as well? No, I'm just kidding.
The other thing we have on the agenda is, we've now had a couple of vice chairs who have timed out on their terms before ever getting to be the chair, and I don't want that to happen to Mr. McGinley. So we are going to have some board elections, and I am going to actually hand the gavel to Mr. Elfman for a second, so I can make a motion to replace
Sure.
me with Mr. McGinley. Yes.
Okay, so just for the record, you're resigning
I'm
from,
resigning the chairmanship.
okay, thank you.
And I'm nominating Blaise McGinley to be the replacement chair for the remainder of my previously elected term.
Excellent. Is there a second?
Second.
Is there discussion? Could we just do a voice vote?
We
Okay.
do a
All in
voice
favor, aye?
Aye.
Aye.
You don't get a
I've
vote,
got a second
Blaise.
motion because now we're bereft of a vice chairman, and that is to make Howard Elfman the vice chair.
I'll second.
Gavel back.
Second?
Motion and a second. You still have the chair.
That's what I was going to say. You can have your gavel back.
I can't. I
Counter
just
gavel.
made the
Can't.
motion.
Already left.
Okay. All in favor, say aye.
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 Those opposed? Okay, both motions carried.
Congratulations, Mr. Chairman. Not effective till the next meeting, I take it. So, motion to adjourn?
So moved.
There we go. We are adjourned.
You.